All right, we're going to continue our discussion of legal issues in corrections in week 4. We're going to start part 2 of your textbook, Constitutional Law of Corrections. This week we're going to look at chapters 5 and 6. Chapter 5 starts with a general view of a prisoner's rights under the Constitution, a detailed study of constitutional law, applying it to the corrections management and operations areas. It's kind of an overview of what's in Chapter 5, the nature of prisons. Section 1983 in the Constitution is a big part of it. Defenses, how you might protect yourself, inmate grievances, the PLRA, and prisoner rights in general. These are kind of some old statistics. As of December 31st, 2002, state and federal prisons house 1.3 million inmates. The number of female inmates increased to almost 5% in 2002, and twice the increase of men. But men still are almost 15 times more likely to be confined. At the year end 2001, about half, 49% of state inmates were serving time for violent crimes. Mission statements in prisons, common traits would include protect the public, provide safe and humane environments, provide inmate with self-improvement opportunities. There are 3 types of prisons. Generally, there's max, men, and medium security. Max security would be something like double walls or fences, highly controlled. Medium would be single fence or wall. Inmates can move around unescorted, but they're frequently supervised. Men would be single or no fence and less restricted movement. There's also supermaxes. I guess that would be another category. Those would confine inmates who are unable to even adjust within max security. Examples might be a gang member or inmates who've killed another inmate or staff. Supermax is even more tightly controlled. It could possibly even have a courtroom in the prison institution to limit the inmates' movement. There's also administrative institutions. Examples might be a medical center or a detention facility. They have institution placement objectives. Primarily, that's providing the least restrictive movement while providing the most appropriate level of control. There's efforts made to standardize the process and usually relies on staff professional judgment as an essential part of their designated process. Example of standardization would be assigning points to various factors like age, prior record, nature of the offense, and then designating which institution an inmate would go to based on their total points. Prison's a community. There's very specific outer boundaries. Their prisoner is in control through prison administration. They've got guidelines, like a community often does, a method for control, like discipline. There's a lot of the things like work, education, recreational opportunities, commissaries, visitation, correspondence, telephone. But freedom is a missing aspect of the prison community. The freedom to go, come at will. There's usually a high degree of uniformity in rules and controls or what's expected. Examples could be when you can move around, service of meals, retention of personal property. The idea is to be firm but fair. If you didn't have a firm but fair environment, it can create potential disruptive situations within the prison. In fact, it could create a community where it develops kind of an underground or dissension among the inmates. There's also pain associated with imprisonment, primarily around deprivation, things like liberty, goods and services, heterosexual relationships, or at least the opportunity for them, autonomy, the ability to move around, security, concerns for personal safety while imprisoned. Litigation in prison is going to talk a lot about that. It can be a coping mechanism. be a number of different reasons why inmates bring lawsuits. It could be justified. It could be frustration because there's no other outlet. It could be uh, because it's fancy. It feels like it'd be fun to do. What else? There's nothing to lose, or just untrue. I mean, maybe even harassing prison staff. Regardless of the reason, all these lawsuits need to be treated seriously. Otherwise, regardless of the reason for them, they could have an adverse judgment on the um, prison staff. Prison staff are, I would say, the most vital component of prison management. Correction staff need to be trained in how to handle a variety of situations, how to supervise, develop and use good interpersonal skills. If you didn't provide effective, sound training, it can lead to staff being sloppy, abusing their power or authority, create tension in the prison for both the inmates and the staff. So this is a huge part of prison law. Section 1983 in the Constitution, in fact, it's the most common means for taking legal action against prison officials. Used to establish most of the constitutional rights afforded to inmates. It's really wider in scope than judicial review, and there's broader relief opportunities under 1983. The U.S. Constitution, with the U.S. Supreme Court interpreting, is the final decider of constitutional provisions. How would you protect yourself? Really, there's not an absolute immunity from being sued. The best thing to do is follow procedures, instructions of your supervisors, obtain good training, especially in areas where there's the greatest exposure to constitutional liability. Become familiar with the law in your jurisdiction. While you're taking this course, find a good mentor. Keep good records. It helps to have good legal counsel, not just when somebody's sued, but to make sure that the institution is using constitutionally and statutorily sound procedures. Even if you're really trained, be the first to report to work. Watch, listen, watch what folks who have more experience are doing. Inmate grievances is a big part of this. They might have a complaint. Perhaps this is a way of something short than litigation. Trying to create a uniform means to consider the complaint. Here are some methods that might happen: mediation, arbitration, ombudsman, hearing panels, advisory groups. Without some kind of ability to get redress or having a grievance heard, that can lead to frustration among prisoners, and then that can translate to anger and disorder. Most common way is a written grievance system with written rules that provide for an opportunity for inmate to file, time limits, a description of the action, emergency handling procedures, safeguards against reprisals for filing a grievance, and at least a one level of appeal. Some benefits to a written grievance system would include reducing frustration I mentioned earlier, ability of staff to identify problem areas, if there's constantly the same grievance or it's against the same person, which also could be harassment, but hopefully to kind of handle the situation without the court having to be involved. If it's used properly, it can diffuse hostility. It reduces the likelihood of a lawsuit. If there is a lawsuit, at least it can provide some background information. There are some weaknesses. It can't provide all types of relief. It may not cover some of the greatest complaints in inmates, like disciplinary action, medical, and it can result in clogging up the system with frequent flyers, folks who file grievances all the time, and kind of a feeling that the grievance is not heard or no relief is granted. The success of these grievance programs really depends on how well they're administered and supported at a management level. There is an exhaustion requirement. Most courts will require somebody to go through any administrative remedies before they file in court. A big part of the chapter is the Prison Litigation Reform Act, or PLRA, signed in Law 66, codified in 42 U.S.C. Section 1997E. The objective is to reduce the number of state prisoner suits brought in federal court. It requires an inmate to exhaust administrative remedies before filing suit with respect to prison conditions under Section 83 or other federal laws. If you look in Chapter 5, page 88, it has the U.S. Court of Appeals for the District of Columbia Prison Litigation Reform Act, and also in the back, Appendix 5, I think it is, page 553, also gives instructions for filing a complaint under Section 1983. The PLRA continued. There are other limitations. Frivolous or malicious, ill-founded suits can be dismissed without requiring exhaustion. Attorney fees are limited. There's no federal civil action. It can be filed by an inmate for mental or emotional injury while in custody without prior showing of a physical injury. And we'll discuss more of that later in the text. The PLRA continued. It provides a process for informal paupers or without funds, and as a result, they're excused from paying court fees. You would need to submit records showing a lack of funds in an inmate's prison account. Court orders for relief from prison conditions are strictly limited. Consent decrees are limited in scope of relief and limited use of authority of a special master in prison cases. More on the exhaustion requirement. In Booth v. Turner, the court said an inmate must complete a prison administrative process capable of addressing the inmate's complaint and provide a formal relief, even if that process provides no monetary relief. The focus is on the exhaustion of the processes, not the form of relief. Portal versus Nuzzle is a 2002 case that held that the PLRA's exhaustion requirement applies to all inmate suits about prison life. There's still some conflict in whether non-exhaustion is a defense. An affirmative defense must be raised and provided by the defendant official. Currently, there's a split in the circuits. I think the Ninth Circuit stated that non-exhaustion was a defense. The Sixth Circuit, our circuit, requires an inmate to state that he has exhausted all available remedies. That was Brown versus Toombs in '98. Prisoner rights in general. If a corrections worker finds themselves involved in a lawsuit, despite their efforts that we talked about, they need to obtain representation, cooperate in all stages of legal cases, and have knowledge of the law, not only at a local level, but the constitutional requirements. If you look at box 5-1 on page 81, it lists the articles and amendments to the Constitution. Looking at Chapter 6, access to the courts, the chapter looks at how inmates get into court to get their complaints heard. We just finished talking about kind of the grievance process in the prison and exhausting administrative remedies. The amendments don't specifically provide this right, yet the courts have, most importantly, the Supreme Court found that inmates do have a right to access to the court. This is distinguished from the habeas corpus writ that we talked about, Article 1, Section 9. That writ provides only special release, the release from illegal confinement, and it doesn't address the other complaints that inmates might have. It's kind of opening the gates, as we noted earlier. Until the 60s, the court generally had a hands-off attitude toward prisons and inmate complaints. Pre-60 and ex parte Hall, Michigan regulation required prison officials to review inmate legal documents before the inmate could send them to court. The U.S. Supreme Court struck down that regulation, leading to a decision for the principle that prison officials can't screen or censor or interfere with the inmates' submissions to court. In Houston v. Lack, 1988, the court held that an inmate's appeal was filed on the date it was dropped into the prison mailbox. Ruling recognized the inmate had no discretion as to getting his document to court, and that all she can do is to provide the mailing to prison officials. Effectively, this removes the adverse impact that can be caused by any delay on the part of prison officials. Johnson v. Avery, 69, leading part of the abandonment of the hands-off philosophy. Prison regulation barred one inmate from assisting another in preparing legal documents. The inmate was disciplined for violating the regulation. This is what we would call a jailhouse lawyer. The court noted in Hall that inmates were to have access to courts to present complaints. The court held unless the state provided a reasonable alternative to help inmates prepare petitions post-conviction release, the prison could not enforce regulations barring inmates from assisting each other. Shaw v. Murphy in 2001, prison regulation barred inmates in separate housing locations from assisting another. An inmate, a law clerk, was charged with and found to have violated prison regulations, including interfering with the due process hearings. The inmate sued, in part claiming violation of First Amendment rights, including the right to provide other inmates with legal assistance. In a case, the charged inmate had been offered the assistance of another law clerk. The court held that inmates do not have such a special First Amendment right. It cited Turner v. Safely in 87. The standard was that restriction on inmates' constitutional rights are allowed if there's a reasonably related, to a legitimate penological objective. An inmate not able to show prison regulations were unrelated to such objectives. We'll talk about Turner in more detail in Chapter 7, I think it is. Bounds is a big case, expanded Johnson v. Avery's constitutional protection. The issue there was whether states must protect an inmate's right of access to courts by providing law libraries or alternatively sources of law information. The lower court found the state did not have to provide assistance for inmates to prepare petitions to the court. The district court required the state to come up with a plan to ensure access to the courts. The state responded with a plan to provide 7 libraries and facilities around the state, and the inmates objected to that, saying it did not go far enough. The district court approved that plan and held the state did not have to provide legal assistance in addition to libraries. Appeals court affirmed with one amendment that female inmates were to have access to library facilities similar to men's. The Supreme Court held that the fundamental constitutional right of access to the courts requires prison authorities to assist inmates in finding meaningful legal papers by 1, providing prisoners with adequate law libraries, or adequate assistance for persons trained in the law. Law libraries are not constitutionally required. There can be alternative means of adequate law assistance. The court basically left the decision of the means of doing this to the states. Access to courts guaranteed for habeas corpus and civil rights violations in complaints under Section 1983. In practice, there's no distinction made in most prisons on inmate legal actions, even if it isn't falling under one of those categories. Most prisons today have some kind of law library access. Example of adequate legal assistance might be a paralegal working under a lawyer's supervision, hiring lawyers, volunteer attorney assistance programs. Lewis v. Casey in 1996, the lower court at the federal level held that the Arizona Department of Correction wasn't meeting the Bound standard and said that the department was providing inadequate assistance. The Supreme Court criticized the lower court for not deferring to the judgment of the prison officials regarding the type of law library and other legal assistance. The court held the lower court ruling on the type of relief was too broad based on a limited number of inmate complaints. The court said a record indicated only 2 inmates were shown to have been injured. The court held only limited relief to address specific violations should have occurred, not a system-wide corrective plan. It limited the guidelines of bounds, held the inmates' rights to court access encompass these things: direct appeals from convictions, habeas corpus, Section 1983. Required assistance was that needed for preparation of initial filing, not for later litigation steps. The Supreme Court didn't overrule bounds; it just limited it. The court also emphasized the message of deference to prison authorities. In Murray, counsel need not be provided to inmates in collateral attacks on their sentence, even in death penalty cases. Wolff and Martinez, these are cases dealing with attorney-client contacts. There needs to be a balance between the government's need for oversight and the need of an attorney and inmate to have adequate opportunities to communicate with each other. Wolff was primarily a prison discipline case, but one part of the decision governed inspection of attorney mail sent to inmates. A Nebraska regulation provided for inmate legal mail to be opened, not read, and inspected for contraband, and that had to occur in the presence of the inmate. The court held that attorney mail required more protection than ordinary mail. When mail is identified in the envelope as attorney mail, the court approved the mail being opened and inspected, but not read in the presence of the inmate, because it served the security concerns and protected confidentiality. Martinez primarily dealt with inmate mail restrictions, but also addressed attorney visits. In that case, the issue was whether it was permissible for California to restrict attorney visit privileges to members of the bar and licensed private investigators. The lower court ruled the regulation was an unjustifiable restriction on the right of access. The Supreme Court agreed, but recognized that any requested practice must be weighed against the legitimate penal interests. As a result, we've got paralegals and law students, professional assistants who can make legal visits in the same way attorneys can. Attorney needs to identify the person who's going to make the visit and is responsible for supervising the assistant. There's some protection from frivolous complaints, or what we call frequent flyers. Inmates do have a right to access to the courts, but they shouldn't abuse it. There have been some recent legislative action, back as far as the PLRA. Court interpretations have led to procedures to prevent such abuse, making inmates pay filing fees, dismissing frivolous claims, some type of 3-strike provision.